The DOJ's antitrust trial against Google resuming this morning as the Federal Trade Commission's case against Meta heads into its third week. And the Wall Street Journal editorial board weighing in on the case is writing, quote, competition solves market problems better than regulators who keep measuring monopoly by markets that evolve faster than a bureaucracy can keep up.
Federal Trade Commission Chairman Andrew Ferguson joins us now. Chairman, good morning to you. Thank you so much for joining us. So as I'm sure you saw, the Wall Street Journal editorial board is critical of what you're trying to do in these two cases against Google and Meta, saying they stymie innovation. So explain what you are trying to do here and your response to the editorial board.
Yeah, good morning. Thank you for having me. So I think President Trump called it the China-loving Wall Street Journal yesterday, and I think that's exactly right. I do agree with what they said in that competition is better for America than regulation, but antitrust enforcement is how we protect competition. You know, competition is what makes America great, and antitrust is the safeguard that makes sure that American companies and American markets remain competitive. And that's what the Meta case is about making sure that giant companies with tremendous power compete on the merits rather than buying up competitors. We want competition. We want growth. Competition is how we achieve innovation, and that's what the case is about making sure that everyone's competing on the merits, which protects all Americans and helps us all flourish.
So how do you navigate that balance, wanting conservative free market principles to take hold versus the need to regulate as in your role as a regulator?
Yeah, it's a great question. So free markets are the best thing that we have, to allocate resources. Free markets are also what allow, ordinary Americans to pull themselves up by their bootstraps and achieve. That's part of the American dream. And I don't think regulation is good, and antitrust enforcement isn't regulation. The last 4 years, the previous administration, they were all about rules, rules, rules. Ex-ante regulation was the name of the game. That's not what we're about in the Trump administration. President Trump promised to deregulate, and he's delivering. At the FTC, we're leading one of the major deregulatory campaigns by eliminating anti-competitive regulations. But antitrust enforcement isn't regulation. It's just law enforcement. Congress has written the antitrust laws and has assigned the FTC and the DOJ to be a cop on the beat and make sure that everyone is playing by the competition rules. And if someone isn't, the FTC is going to go to court. But other than that, the FTC needs to stay out of the way and let our markets grow. And that's why we're leading President Trump's deregulatory campaign by eliminating anti-competitive regulations that insulate monopolies through the use of government power.
Okay, so the FTC has also announced a lawsuit against Uber over the Uber One subscription. And an Uber spokesperson has responded to this lawsuit saying, we are disappointed that the FTC chose to move forward with this action, but are confident that the courts will agree with what we already know. Uber One's sign-up and cancellation processes are clear, simple, and follow the letter and spirit of the law. So for those who aren't following this one, can you explain this case here?
Sure. Congress passed a law called the Restore Online Shoppers Confidence Act. And it's all about making sure that companies with online subscriptions treat consumers fairly, both when they sign up by making it very clear and conspicuous what terms consumers are agreeing to when they sign up, and by requiring a simple method of online cancellation for online subscriptions. It's one of the most important laws Congress has passed in the last decade and a half to protect the way that Americans shop online. And it's all about fairness. And, the FTC investigated Uber for a long time and concluded that the sign-up method and the cancellation method wasn't consistent with the laws that Congress passed. And that's why we've taken Uber to court. But this isn't about, sort of a campaign against big tech. All Americans spend a lot of time online as shoppers participating in online commerce, and the FTC's job is to protect consumers and to meet consumers where they are. And because consumers spend a lot of time online with subscriptions, it's important that the FTC enforce Congress's law that's designed to protect shoppers online, and that's what the suit against Uber is all about. It's just making sure that online subscription firms like Uber are treating American consumers fairly.
Well, we're approaching the first 100 days, and I'm sure that this period of time has been a whirlwind for you, but you're getting a lot of things done, and we thank you so much for joining us this morning. Chairman Andrew Ferguson, we appreciate it very much.
The Supreme Court on Monday backed President Donald Trump's decision to fire a commissioner on the Federal Trade Commission. sending yet another signal that the High Court intends to revisit a 90-year-old court precedent about executive firing power. The temporary decision to maintain Biden-appointed Commissioner Rebecca Slaughter's termination was issued 6-3 along ideological lines. The Supreme Court set oral arguments in the case for December. Trump's decision to fire Slaughter and another Democrat-appointed commissioner, Alvaro Bedoya, faced legal challenges because it stood in tension with the FTC Act, which says commissioners should only be fired from their 7-year tenures for cause, such as malfeasance. Trump fired Slaughter and Bedoya shortly after he took office without citing a cause other than the president's broad constitutional authority over the executive branch. Bedoya resigned, but Slaughter vowed to fight her firing in court and see the case through to its conclusion. A lower court initially sided with Slaughter and reinstated her, but she has since been fired and rehired several times as her case made its way to the Supreme Court. Monday's decision came after the Trump administration asked the High Court on an emergency basis to temporarily pause Slaughter's reinstatement while it considers the merits of the case. The Supreme Court's decision to keep Slaughter's firing intact means she will remain sidelined from the FTC until after the High Court hears arguments about the case in December. The case raises a pivotal question of whether Trump has the ability to fire members of independent agencies as the president pushes for a more unified executive branch. Independent agencies such as the FTC, various labor boards, and the Securities and Exchange Commission have long been insulated by law from at-will firings. Slaughter had argued to the Supreme Court that siding with Trump, even on an interim basis, directly flew in the face of the precedent set in Humphrey's Executor versus the United States, which deemed President Franklin D. Roosevelt's firing of an FTC commissioner unlawful. Legal experts have speculated that the current conservative-leaning Supreme Court is interested in narrowing or reversing Humphrey's Executor, which could carry broader implications about a president's ability to fire members of certain independent agencies. The 3 liberal justices dissented and would have denied Trump's stay request. Writing for the dissent, Justice Elena Kagan speculated that the court's majority may be raring to reverse Humphrey's Executor. She said, though, that it should not make decisions on the shadow docket that contravene that precedent and instead wait until such a reversal happens. Our emergency docket should never be used, as it has been this year, to permit what our own precedent bars, Kagan wrote. Still more, it should not be used, as it also has been, to transfer government authority from Congress to the president, and thus to reshape the nation's separation of powers.